global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, good people. Welcome back to our channel. Since from the time or the advent of the emergency rule in Rivers State, the sole administrator has taken some very unconstitutional move which has left Nigerians with multiple questions about who is empowering him. Now, the legislative committee charged with the responsibility of overseeing how things are run in Rivers State had at one point demanded for explanation, but then he said they should give him more time. But you're going to hear some of the key questions that have been shot out to these legislative 21-man legislative committee to ask Ibas, which will go an extra mile to tell us where we are heading because of some of the unconstitutional move he has taken. Let's dive into full details of what a legislative expert, a legislative lawyer by the name Clinton Jaja have to ask the House of Rep to extend to Ibas in an open letter he wrote today. A legislative lawyer, Dr. Tony Clinton Jaja, has asked the House of Representatives ad hoc committee on oversight of the state of emergency in Rivers State to question the sole administrator, Ibas, over unconstitutional step he has been taking in executing the emergency rule proclamation in the states. Reported that Ibas on 25th of April 2025 honored the invitation of the House Committee but pleaded for more time to properly brief the lawmakers on the situation in Rivers State. The meeting was summoned in line with the House of Representatives' resolve to take over legislative duties in Rivers following the suspension of the State Assembly for the 6-month period of the emergency rule. The governor, Similare Fubara, and his deputy were also suspended for the duration of the state of emergency. In an open letter addressed to Professor Jake Dan Azumi, head of Secretariat of the Reps Ad Hoc Committee on Rivers State, Jaja, a legislative drafting expert, highlighted the unconstitutional action taken by Ibas in administering Rivers State, over which he said lawmakers should demand answers from the sole administrator. The letter, dated 28 April 2025, entitled Open Letter to Professor Jake Dan Azumi, head of Secretariat of the Ad Hoc Committee of the House of Representatives on oversight of the state of emergency in Rivers State, questions that the sole administrator must answer regarding dissolution of the Rivers State Judicial Service Commission, appointment of local government sole administrators, and exercise of core legislative function by the sole administrator. Jaja, director of the Center for Legal, Parliamentary and Printing Council, Pty Limited, CLPPC, noted that the sole administrator of Rivers State, being a creation of a legislation of the National Assembly, namely the Proclamation State of Emergency Rivers State 2025, is subject to the oversight of the National Assembly. The letter added that there are many issues that your committee ought to provide clarification where you finally get the chance to hold a meeting with the sole administrator of Rivers State. Let me point out some as follows. That the proclamation of a state of emergency in Rivers State does not imply that the legislature and the will of the people was removed and replaced by a military-style dictatorship. It appears that the sole administrator of Rivers State and his legal advisors are of the opinion that the legislation that proclaimed a state of emergency in Rivers State gave him the powers to perform legislative functions. This wrong impression is far from the truth. Section 3 of the said legislation specifically stated that the only form of legislation to be enacted is regulations, and regulations are a form of subsidiary legislation that are made pursuant to a primary legislation, which in this case is the proclamation of state of emergency in Rivers State 2025 as enacted by the National Assembly pursuant to Section 305 of the Constitution of the Federal Republic of Nigeria. Even the said regulation which the sole administrator is authorized to enact are subject to the prior approval of the President of the Federal Republic of Nigeria as specified under the proclamation of the state of emergency in Rivers State 2025. The judgment of the 28th February 2025 of the Supreme Court of Nigeria was specific in stating that it is never in the contemplation of the Nigerian Constitution that a military dictatorship, or in this instance, a sole administrator of Rivers State, would replace and override governance by the people through their representatives as constituted by a legislature. It is true that the said legislation suspended the entire members of the Rivers State House of Assembly. However, it did not suspend the representatives of the people of Rivers State at the National Assembly. Therefore, as representatives of the people of Rivers State, the ad hoc committee on oversight of Rivers State is humbly appealed to question whether there was any input of Rivers State people or their representatives regarding the sole administrator of Rivers State when he appointed 23 local government area sole administrators for the 23 local government council of Rivers State and other action involving appropriation of funds of the Rivers State government, bearing in mind that by its judgment of July 2024, the Supreme Court of Nigeria has laid down a ruling of law that it is illegal for LGAs in Nigeria to be administered by non-elected officials, and it is also illegal to allocate funds to any such LGAs that are administered by non-elected officials. The lawmaker or the lawyer equally said that the lawmaker should ask the sole administrator where he derived the power to unilaterally dissolve the Rivers State Judicial Service Commission and other similar statutory agencies such as the Rivers State Independent Electoral Commission, the RISEC, without the approval of any legislature. Assuming the sole administrator of Rivers State is to argue that he derived the power pursuant to Section 3 of the proclamation legislation. The said proclamation legislation only empowers the sole administrator to enact regulations which are a form of subsidiary legislation, and there is no way on earth that a subsidiary legislation can be enacted to nullify or amend the wordings of a primary legislation, such as Rivers State Independent Electoral Commission Law Number 2 of the 2018. There are many other questions that the ad hoc committee on oversight of the state of emergency in Rivers State ought to ask the sole administrator, such as where he received legislative approval for the appointment of a secretary to the Rivers State government and other officials who are to receive appropriation from the funds of Rivers State, whereas the Constitution of Nigeria is clear that only funds appropriated and approved by the legislature can be expended. Jaja stressed that the duty of the ad hoc committee is essential to proclaim or to confirm that the proclamation legislation has been compiled with to prevent autocratic conduct by the sole administrator. Wow, these are some of the very salient things that they just had to put across to the sole administrator, because it is outrightly wrong for some of those things to be done. The legislative expert is absolutely right in some of the questions he has thrown across to, Ibas. But don't forget that there were certain instructions that were given by, or that was given by the president in respect to his position as a sole administrator. And I believe strongly that he's acting according to the demand of the president. Unfortunately, that is where we are right now in Nigeria. Everything seems to be nosediving, and illegality seems to take the upper, part. Constitution is being carried out based on how it suits the sitting president or suits the people who are in charge of the state. Unfortunately, it's not the governor that is in charge, but the people, who are carrying themselves as number one. But however, I think that some of these questions, we are yet to hear any reactions coming from, the ad hoc committee, 21-man ad hoc committee, who were charged with the responsibility of overseeing what is going on in Rivers State legislatively. But however, at a time like this, let's sit back to watch what will transpire, because if some of these questions are not asked, posterity will judge all those who were positioned to correct some of this abnormality. Let's meet our commission and talk more. Do you think that this question posted by the legislative expert, legislative lawyer Clinton Jaja, will be given any preferential treatment, just to see how things can be corrected?